you very much. Uh, Last couple of days, we heard two words, mostly hundreds of times. One is conventions, and the other one is English law. English law has been a topic for the last couple of days or for the last 5 years. Wherever you talk about maritime industry, you talk about English law. It's almost unavoidable. So the question is, why is that? And we all have some idea for various historic reasons, etc., etc., etc. But as an introduction to my topic, how Brexit is affecting EU maritime industry, I'd like to say a few words about why it is that with English law, particularly to younger colleagues of us who didn't have much, maybe, contact or experience with English courts, English law contracts, etc., etc. How do I go with this? Okay. There is an expression called the legal London. I like this expression because it includes all what maritime industry is getting from London, and some people say from City of London, because it encompasses the whole levels of services which is operating there. Lawyers, judges, arbitrators, technical experts who come as witness experts in various proceedings, etc., etc. So not to always mention each of these services which are available there, people will call it legal London, which encompasses the whole area of services available to maritime industry. And that's been the case for centuries, as you know, history, blah, blah, blah. About 80% of all commercial cases decided by commercial courts in England are related to carriage of goods by sea and marine insurance. That's what my search found in many, many articles, etc., etc., about 80%. Because maritime industry is very international, about 70% of the parties involved in the cases and disputes are foreign. So that's additional touch to the expertise of English courts and judges to deal with foreign parties all the time. First 100 years of commercial court in London were dominated by disputes arising from carriage of goods by sea and marine insurance. We heard yesterday and today, and from Professor Thomas, talking about the insurance, how many cases all related to actual English law and judgments made or decisions made by English commercial courts. This is all done not only by commercial judges in high court, for example, but also by less practitioners, as I mentioned. So there's barristers, experts, technical experts, etc., etc., everything which is available there. Shipping law has played traditionally very important role in general commercial law in England. Lord Gough, I would quote him, who died, I think, 2016, said if you talk to an Englishman about commercial contract, he would assume you're talking about contract for carriage goods by sea. So the maritime industry has been so deeply embodied in commercial reality there, and the expertise and judgments made by English courts are all, as I not repeat myself again, are predominantly based on disputes arising from carriage of goods by sea and marine insurance. Also, legal London contributes billions of pounds to local economy, to UK economy, and also is responsible for billions of pounds of export of services. Because, as I said earlier, international maritime community comes mostly to London. English procedure in admiralty law has become so, for the last many years, has become so advanced and sophisticated, so much that it has become almost a model for many other jurisdictions. Not long time ago, I read an article where the Rotterdam judges say that for the last 20 years, they've been looking very carefully and in detail how their colleagues in London deal with the construction of contracts, particularly. Therefore, English law has achieved a dominant position in international trade, and as we know, it has ratified, the UK has ratified all major maritime conventions. We mentioned PIMCO several times these days. That's one of the examples again. We all know who PIMCO is. Association which has more than 3,000 members in more than 130 countries worldwide. Among many other things which PIMCO does, they produce, as you all know, summary documents which are daily used everywhere. Charter party agreements, bills of lading, 7 purchase of ships agreements, refund guarantees, charters, guarantees, etc., 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 etc. They all have English law and jurisdiction of English laws clause. In addition to US, of course, so it gives the opportunity to those whose trade is concentrated in that part of the world, maybe to the US, but otherwise, again, it's jurisdiction of English laws and English law. Few examples in real life. Professor Thomas mentioned today P&I and who can have a direct action against the P&I insurers. In 1989, I think, or 1990, there was a case before came to the House of Lords. You probably know about this Padre Island and Funky case, where the issue of direct action against the insurer was the issue. Pay to be paid rules applied generally everywhere, but there was just one hint made by, I think, Judge Wolf on the House of Lords saying pay to be paid rule is fine, but we would not expect that rule to apply in personal injury or death claims. Just that hint made all P&I clubs associations to meet together to gather what we are going to do with P&I without pay to be paid rule now. And they have all agreed and understood. We cannot request pay to be paid rule to apply in personal injury and death claims, especially in cases where the insured is facing the bankruptcy proceedings. So what I'm mentioning is that just one hint was enough by this judge to make the whole industry to rethink their standard policy and the facto changing. I'll give another example. We were representing a shipyard in arbitration in London, and we lost. But there was some funny legal issue there, tricky a little bit. So we went to the High Court to ask for leave to appeal the arbitration. It doesn't happen every day, but in certain cases, you might get leave to appeal on the arbitration. After we got the arbitration award, let's say it was Thursday or Friday, we fixed a meeting with Judge, I think it was Lord Phillips in High Court, to listen to our case, to decide whether to give us a leave, to give us a leave or not to give us a leave. He decided to give us a leave. That was Monday. We were in the Court of Appeal on Thursday. I can't imagine in many countries that speed of the events happening. It was about $20-something million hanging And this awareness of the commercial reality is another thing which brings the maritime world to London to be to have their cases decided by people who have this commercial reality understanding. Why is that? I'll come to that. I'll come to that a little bit later. Now, we heard also from Daniela today about Brussels Convention, Brussels One recast, etc., etc. Apart from major international maritime conventions, we all know UK was a part of the Brussels Convention. We'll mention that later of Lugano as well, but in Brussels Convention and also in 2015 they went for the Brussels One recast, which made recognition and enforcement of judgments in any other member state more straightforward. Brilliant. So you get the judgment for English court against German company or Italian company can go with the judgment there and they should proceed as in the same way as it was their judgment. Brilliant. Exequatur proceedings being abolished by the recast. So it all went smoothly and fast. Excellent. However, as we all followed, Britain has decided to leave the European Union, and it had direct effect on the Brussels Convention, and it had direct effect on Lugano Convention. Lugano is a bit funny. Recast one, Brussels Recast one has ceased to apply to the UK, and I'll come back to Rome later. Has ceased to apply, so no more shortcuts anymore. The party finished. Lugano Convention was the last branch to grab, but EU has resisted and said that they didn't think it was really time to consider taking the UK to the Lugano 1988 Convention in 2007, which was funny because there are other countries which are non EU countries members of Lugano, like Norway, like Iceland, like Switzerland, I think. Anyway, so that issue is still hanging. However, there are lots of politics involved in that, but who knows? So the party is over. The question arises, what shall we do with the London days? What should we do with all these highly and deeply experienced judges in London and their judgments if we can't enforce it easily as we did in other European countries? Rome 1, Rome 2, okay, that's been embodied in English law for many years. That doesn't change much, and the parties' agreement on the choice of law for contractual obligations, but also Rome 2 means that there is no reciprocity between EU and UK here. So any decision by the parties, agreement by the parties will be upheld in other European countries. So that's something you can agree on English law and in your contract, and that will be upheld in other countries because of the Rome 1 and Rome 2. There are two conventions. Somebody said, well, what's the trouble? There is a 2005 Hague Convention, 2018, another Hague Jurisdiction Convention, which are also dealing similar with mutual recognition and enforcement of judgments in other countries. Yes, that's true, but for us here, that's irrelevant because neither of these conventions dealing with anything to do with maritime. They don't apply to maritime claims, they don't apply to liability, limitation of liability for maritime claims, they don't apply to maritime pollution claims, nothing. So it's fortunately it doesn't help anybody, really. So Brexit has affected definitely EU maritime industry more than any other sector because of these reasons which I just said. Other reasons are okay, other sectors are okay, which I can't specify Kate mentioned. But maritime sector has been at least badly hit. One would say, but what we're talking about in reality? When did you see last time European company versus another European company going to English port in shipping? Probably rarely, because you could probably see Panamanian company going against Liberian company in front of English port. That's what you can see, that's for sure. However, many, as we know, many contracts, many transactions between offshore companies are very often either guaranteed or warranted by their European corporate mothers, whatever you call it. And very often this is where you're going to enforce your claim against the guarantor, which is probably sitting somewhere in Europe with assets. That's why Brexit is not very good news. However, I think the question arises. Just a point. Arbitration obviously is not affected by Brexit. No status, anything to do with arbitration has been affected because it's subject to New York Convention, 1958. So arbitration is out, which helps those who agree English law and arbitration in London, for example. All, say 95% of shipbuilding contracts worldwide are governed by English law and have arbitration in London courts, even European shipyards, etc. But Brexit doesn't affect us. Well, coming now to whether parties should continue or discontinue to choose English law as a governing law in their maritime contracts and jurisdiction English ports. Yes, no. I would ask, what is the alternative? I don't know what is the alternative. I personally think that Legal London will remain to continue to be a forum of choice for maritime disputes and resolution. And why? Because English legal profession is outstanding quality, and that's what maritime industry needs. They need outstanding quality. We are talking about billions of dollars or euros or whatever involved, and it's very serious business. And English courts respect party autonomy. This is extremely important for commercial people in maritime trade, especially because it's very international, very business-like. So respect for party autonomy, and also the aim of the courts to give effect to the contract, not to create it, not to create what some European countries want to create. We know what the parties have in mind. So we'll tell you what the parties have in mind, and this is the contract, what they invented in the courtroom. I'm not doing construction and interpretation, this is what is the court. Here. I would quote Mr. Justice Foxton of the High Court, whom I met ages ago. He was junior barrister then, he is now Lord. It's so funny to see this age. He said that mere fact that about 65–67% of all judges in the High Court or Circuit Commercial Court, that about, I don't know, figures, for example, 3 out of 5 of Court of Appeal judges, and I don't know, 5 or 7 or 3 or 5 of the Supreme Court judges have some shipping experience. And I think that is why I think English law and English jurisdiction will remain important in the maritime industry. I think so. Thank you.